Amendment 3, Missouri's Reproductive Freedom Ballot Initiative, is being challenged in court. The opponents to Amendment 3 argue that it was written incorrectly and that it should have included the portions of state statutes that it's overturning. A judge agreed, but he wasn't sure he was right, so he ruled quickly to give everyone time to appeal, and that's what they did. The case will be argued at Missouri Supreme Court on Tuesday, September 10th. That's the deadline day for ballots to be finalized here in Missouri. At stake is whether or not Amendment 3 will in fact be on the ballot this November. The ruling sure seems wrong to me for three big reasons. First, there's an argument about the form of the initiative itself. Amendment 3 is an amendment to the state constitution. There's a difference between our state constitution, which is changed by amendments and always by a vote of the people at the end of that process, and our state statutes, which are changed by propositions that can be on the ballot or by bills passed by our state legislature. That's what they do. Amendment 3 only adds to the Constitution. Its language doesn't add or subtract from any state statutes. So how can the amendment include which laws it's changing if, by definition, it's not changing any of the statutes, any of those laws? This is the first case to find that a proposed amendment has to include which statutes might be impacted, even though the amendment cannot, by definition, change statutes. I don't think that's right. In cases going back to 1910, all appear to agree with that too. Second, there's a substance argument about what's included in Amendment 3. Amendment 3 changes the way reproductive rights are protected in Missouri. The amendment makes it much harder for the government to take away reproductive rights by changing what's called the standard of review. In this situation, the standard of review is the way a court must review a law to determine if it is constitutional or if it's not. If Amendment 3 passes, Missouri's extreme abortion ban, which is so extreme, even Donald Trump and Josh Hawley are now criticizing it, would have to be reviewed by a court under the new, stricter standard of review provided by Amendment 3. Think about it from a classroom perspective. It changes the way the law is graded, not the grade itself. The grade would be determined in court later, and a failing grade gets a law ruled unconstitutional and unenforceable. In some cases, those laws actually remain on the books, even though they can't be enforced anymore. They're like zombies in that way, I guess. That's another reason why the amendment did not need to include all of the statutes that may be impacted, and plenty of cases agree with that principle too. Third, the people of Missouri have a constitutional right to collect signatures and put issues on the ballot. Courts are supposed to protect that fundamental right that we have as Missourians. Removing Amendment 3 from the ballot would violate that fundamental right. On September 10th, the court could rule that Amendment 3 needs to be removed or that it needs to stay. That's what's going to happen on that day. If it is removed, the process of signature collection has to start all over. It's not going to be on the ballot. If it remains, it could still be challenged in court even after September 10th, but it would be guaranteed to be on the ballot in November. We would get to vote on it. So what can you do? Well, there's not much that you can do to impact this court decision, and in my view, there shouldn't be too much you get to do. That's what the court is there for. But there's still plenty you can do for Missouri. If you're not already, you can become an engaged citizen who makes sure to hold our government officials accountable when they try to take away the power of the people of Missouri. This is our home, and it's up to us to keep it that way.